Welcome to tonight's event on Lawfare from the West, or Anti-Israel Lawfare from the West, ? Featuring Professor Eugene Kontorovich, barrister Natasha Hausdorff, and litigator and nonprofit leader Joanna Baron. My name is Elana Maizel, and I'm the executive director of the Israel Law and Liberty Forum, which is an Israeli legal educational initiative dedicated to enriching Israel's legal discourse and to cultivating new leadership for Israel's legal profession. Since the start of the war following October 7th, we've also placed great emphasis on diversifying the discourse on Israel in the field of international law, where we hope to give voice to a variety of perspectives, including the advancement of more conservative and pro-Western ideas. So tonight, our learned guest will brief us and engage on a new phenomenon that we're seeing in countries such as the United States, United Kingdom, Canada, and also honorary mention to Australia, namely the imposition of legal sanctions on individuals and entities in Israel, and even seeming penalties sometimes to domestic bodies that provide charitable support or arms to Israel. We're going to explore the underlying stories in 3 of these countries with each of the experts, tease out the extent to which domestic and international legal issues are at play, and discuss potential remedies for the situation. Each guest will have 5 to 6 minutes to present their own case study, and we'll move from there to some general questions. And then between 45 and 50 minutes, we will move to audience questions. So we're gonna get now to our speakers. We first are honored to host Professor of Law Eugene Kontorovich, who is one of the world's preeminent experts on universal jurisdiction and maritime piracy and international law and the Israeli-Arab conflict. He is the executive director of the Scalia Law School's Center for the Middle East and International Law, and a fellow at the Kohelet Policy Forum. Professor Kontorovich has published over 30 major scholarly articles and book chapters in leading law reviews and peer-reviewed journals in the United States and Europe. His scholarship has been cited by appellate courts in the US and around the world, and he's a frequent contributor to the Wall Street Journal editorial pages, as well as to other major global media, including numerous newspapers, magazines, radio, and television programs. Natasha Hausdorff is, Natasha, remind me, the legal director?
Yes, of the UK Lawyers for Israel Charitable Trust.
UK Lawyers for Israel Charitable Trust. And her practice spans both civil and commercial litigation, arbitration, regulatory matters, and public international law. After her law degree at Oxford University and an LLM specializing in public international law, she clerked for the president of the Supreme Court of Israel in Jerusalem. In 2018, as a Pegasus Scholar, she was a fellow at the Columbia Law School in the National Security Law program. She lectures globally on aspects of public international law and national security policy, and she joins us shortly before going out on tour with Douglas Murray in the United States, in what I assume is a tour in defense of Israel and Western civilization, but you're welcome to speak more specifically to that a bit later. And lastly, we are extremely honored to host for the first time Joanna Baron, who has been the Canadian Constitution Foundation's executive director since 2019. Previous to that, Joanna was the founding director of the Runnymede Society. She's a native of Toronto. She studied classical liberal arts at St. John's College and earned civil and common law degrees at McGill University. She clerked at the Court of Appeal for Ontario and was called to the bar in Ontario in 2013. Following her clerkship, she worked in barristers' chambers in London, UK, as a Harold G. Fox Scholar. And upon returning to Canada in 2014, she practiced criminal law with the late Edward Greenspan, appearing at all levels of court in Ontario, including the Supreme Court of Canada. Now, we will kick this off with Professor Kontorovich. A February executive order by the Biden administration imposes sanctions on persons who are undermining peace, security, and stability in the West Bank. Can you talk more to, there's also, of course, a case now challenging this executive order in Texas, I believe. Can you speak more to the content of the executive order, what distinguishes it from other sanctions, whom it's been used against, how decisions on it are made, and obviously the grounds for the challenge? Yeah, I think you're still muted.
Yeah, hold on one second.
There you
Yes. There we go. Anyway, so thank you for having me here. The February 1st executive order by the Biden administration is one of the most consequential and I think harmful developments in the U.S.-Israel relationship, and perhaps one of the worst diplomatic things to happen to Israel since the October 7th war. The United States has long used sanctions in the form of travel bans and asset freezes, bank freezes, against foreign policy actors that they wish to target for foreign policy reasons, as an instrument of foreign policy, as a kind of softer stick than military or other kind of form of sanctions. And because the international banking system all flows through America, the United States has the ability to, by restricting access to its financial systems, to, through a ripple effect, essentially freeze the bank accounts of people throughout the world, or prevent them from interacting with the large banks that are part of the Western and international banking system. Those sanctions have been used, pursuant to various executive orders, against countries like Iran, Iraq, Lebanon, Libya, Mali, Nicaragua, North Korea, Somalia, South Sudan and Sudan, Syria, Venezuela, and to target bad actors involved in areas like nuclear proliferation and drug trafficking. In the entire history of the United States-Israel relationship, with all its ups and downs, the sanctions have never been used to target Israelis. Indeed, as far as I can tell, they have, with perhaps one small exception, never been used to target any official United States allies. But that is what the February executive order does. Now, the executive order is framed as dealing with things in the West Bank. But in its application, it has only been used to sanction Jewish Israeli citizens, have been the only individuals sanctioned under this executive order. And the rhetoric around the executive order was framed through this narrative of settler violence. And one would think it's an executive order about violent settlers. Now, the merits of that as a political question, we don't need to explore here, but it's very important to point out the executive order is not, in its either language or application, limited to either violence or settlers. And in fact, it allows the administration to target, shut down, and chill a wide range of conduct. So there are two, let's say, principal operative provisions. One does, in fact, deal with acts of violence, intimidation, and other potentially unlawful acts in the West Bank, and allows the administration to sanction anyone who commits, let's say, acts of violence, not just limited to murder, but potentially any kind of violence, property crime in the West Bank. That's one part. Another part allows the administration to essentially debank and paralyze the life of anyone who conducts any actions or who does anything that undermines peace, security, and stability in the West Bank. Now, what constitutes undermining peace, security in the West Bank? The executive order is silent on this issue, but the administration has at various times said the two-state solution is necessary for peace in the West Bank. Thus, opposing the two-state solution is bad for peace and security and stability in the West Bank. The administration has said that Jews praying at holy sites in the West Bank is provocative and destabilizing to peace. So, in other words, entirely nonviolent action can be sanctioned. And worse, anybody who associates with sanctioned people can themselves find their bank accounts frozen. And worse yet, one gets no notice for this. So one just wakes up one day and one's bank account is frozen. The obvious effect of it, clearly no violence is required. And we'll give you an example. Recently, the executive order was used to sanction, freeze the bank accounts of a woman, Ruth Ben-Haim, who is not a settler. She lives inside Israel in the town of Netivot, and has not been accused of any acts of violence. Rather, she's one of the organizers of a group called Sav9, which engages in what the administration, the Biden administration, has itself called protest activities. In particular, protesting the delivery of supplies to Gaza, much of which, as the United States admits, winds up in the hands of Hamas. So these are typically, these are parents of soldiers serving in Gaza, parents of hostages, often family members, who do not want Hamas to be armed and supplied by Israel. So the irony is that for Hamas is a United States designated terror group, it is itself sanctioned. For opposing aid to a U.S. designated terror organization, Ruth Ben-Haim and her entire family, because they freeze the bank account of the family, and her family has been sanctioned in the way that terrorists are sanctioned. Now, these executive orders apply to Israelis, but they can also be applied to United States citizens. And as applied to United States citizens, we believe they violate the constitutional rights of the United States citizens. And several United States citizens, in a case that I'm involved in, have brought suit in federal court in the Northern District of Texas, challenging the executive order, first of all, on free speech grounds. If people can be sanctioned for their vague associations with people engaged in activity that the administration thinks bad for peace in the Middle East, it makes it very difficult for pro-Israel activists to defend Israel. What if you want to bring over a speaker to Israel? You don't know if that person's going to be sanctioned by the time they get to the United States, disrupting your event. Now, it also clearly violates equal protection, because while the executive order does not mention Jews or Israelis, the only people who have been sanctioned under this executive order have been Jews or Israelis, despite the fact that the Palestinian violence against Jews far eclipses the opposite. Finally, it's a denial of equal protection. There's simply no way to know what is permitted and what is not permitted. There is no process. You're not notified or asked. And essentially, the way people wind up on the sanctions list is there are several anti-Israel organizations. One of them is called DAWN, which is led by a lady named Sarah Leah Winston, formerly the Middle East director of Human Rights Watch, and organization formerly headed by Jamal Khashoggi. And they sent reports to the United States making various allegations. And essentially, the United States seems to be acting in accordance to these reports without any kind of process. So some of the people who have been accused of settler violence in reports by left-wing organizations in the United Nations are people who have been engaged in self-defense. So now let's say you're a United States citizen and you are yourself the victim of an attack. You're being attacked in the West Bank. You have two choices. You can defend yourself and potentially wind up on a sanctions list, or you can not defend yourself and potentially be killed. That is not a position any American citizen should have to find themselves in.
Thank you, Eugene. I'm going to move now to Joanna to discuss developing situation in Canada, which of course has also imposed sanctions on certain individuals and entities, and also has stripped the charitable status of a couple of, I think, 2 to 3 charitable organizations, one of which is JNF Canada, which is challenging the decision. I'm just going to take a quick second and let the audience know. I see somebody's already used the Q&A box, but if you have questions that you'd like to be asked toward the end of the session, you don't want to forget, feel free to utilize the Q&A box even now, and I will be going through once we conclude with this portion of the kind of official event. And Joanna, to you, please.
Thanks very much for having me. And I want to just emphasize that I'm speaking in my personal capacity today. So I'll tell you about what happened with the JNF in particular. So this month, the federal government here in Canada published notices immediately revoking the charitable status of JNF Canada, as well as another charity called the Neiman Foundation. And these notices were published when members from both charities were observing Shabbat and was applicable immediately. The JNF, as many of you will know, has branches also in the US, in the UK. It plants trees in Israel. It builds dams, reservoirs, creates parks. And the Canadian chapter proudly helped build a 1,700-acre park in Israel, which is enjoyed by Jews and non-Jews alike. And so this revocation has some backstory. JNF Canada was accredited as a charitable entity in 1967, and its charitable purpose at the time was to raise funds for the employment of indigent laborers on various work projects in Israel. And this was approved by, it was then called Revenue Canada. Now it's called the Canada Revenue Agency. I will refer to it as the CRA. That was approved, and it was reaffirmed in 4 subsequent audits over the years. So now the CRA has backtracked, and this has been going back to 2014, and has said that this is no longer a charitable purpose that is valid, but also that JNF cannot update its charitable purpose to include a variety of well-recognized valid charitable purposes, helping the environment, education, social services, but instead just simply needs to be shut down, wound up. And the CRA has confirmed in previous publicly made correspondence that in part, the original audit, which started this sort of round in 2014, was prompted by a petition led by Independent Jewish Voices. This is an anti-Zionist group which has publicly celebrated the revocation decision. And by all appearances, this revocation was done unusually, in a manner contrary to usual practices. The norm is that the CRA would hold off on actually withdrawing charitable status, which of course gives a group an ability to issue tax receipts and other things until legal proceedings conclude, because there is an ongoing court proceeding, which I'll mention in a moment. So normally that would be held off until the court issues its final decision. But here, the revocation was the proverbial rug was pulled out. Now, some of the reporting here in Canada, and I suppose elsewhere, has sort of spread some misinformation about the actual basis of the revocation. So it's focused on controversies over playgrounds and parks that JNF helped to build on IDF-owned property. So I think bases, but also other property owned in Israel by the IDF. But really, the key point of contention has always been this matter of valid charitable purpose, which again was accepted in 1967, and then the CRA changed its mind. And the issue of projects on IDF-owned property was not even mentioned in recent communications with the CRA. Once the JNF understood that CRA took issue with it funding projects on IDF property, it agreed to stop doing it in 2016 as a result of the 2014 audit. In the result, the federal government unilaterally terminated charitable status on August 10th, and JNF is going to appeal. They are suing the minister responsible for the decision, Marie-Claude Bibeau, for acting in a way that they allege was flawed and fundamentally unfair. The CEO of JNF Canada says that their legal team has identified over 200 instances where charities have been allowed to shift their charitable purpose in order to maintain their charitable status. And they also will have a claim, which as a lawyer, I think will be well substantiated, that there is a reasonable apprehension of bias in CRA's decision. So, for example, 2 weeks ago, a union that represents many bureaucrats of this agency put out a post on X saying, as the union representing over 17,000 CRA professionals and an organization that will always stand for human rights, we commend CRA's decision to revoke the JNF's charitable status. Another post, a group called the Professional Institute of the Canadian Public Service declared no organization that uses tax-deductible donations to support war or genocidal efforts in an occupied territory should be able to benefit from Canadian charitable status. And the last thing I'll mention, because this is very much the era where the anti-Semitism at play is very much seen in the double standards. The decision of the federal government to revoke this charitable status, while other groups have their charitable status completely unquestioned, including organizations which are not just pro-Palestinian, but also have a track record of funding and having links to militant groups, is fairly shocking. So I'll just mention one case, although the Toronto Sun has reported on numerous other cases. The Canadian Palestinian Foundation, which describes its objectives as allocating donations and funds to victims of violence in Arab countries, is on record for sending over $14,000 to An-Najah University in Nablus in the northern West Bank, which first of all is not considered a qualified donee under Canadian law, but second of all, and more importantly, has been called by Hamas itself a greenhouse for martyrs. So I'll let you come to your own conclusions as to why that hasn't been investigated and there's no jeopardy over that group's charitable status. But I look forward to your questions and to hear from Natasha.
Thank you very much, and I appreciate the more in-depth look at a specific case. I think Natasha may follow in your footsteps in that regard. Natasha, the question of arms export bans to Israel has been building for a few months in the UK. It's gained steam under the new government. What's the background to the story? Is it actually happening? And how does this fit with a larger pattern of lawfare that we're seeing elsewhere in Europe?
Well, thank you so much. Just this question of arms embargoes is an extremely broad one in the context of the last 10.5 months here in the UK and lawfare. But I thought it might be helpful if I picked up on one case that has been brought by Al-Haq in the High Court here against the UK government over weapons exports to Israel, specifically challenging the decision by the Secretary of State for Business and Trade in December last year, 2023. The decision not to suspend arms export licenses for military and dual-use equipment to Israel, and not to stop granting export licenses, but rather to keep decisions on licenses under continuing careful review. Now, that decision in December was reached on the basis that there was not a clear risk that items exported to the IDF might be used to commit or facilitate a serious violation of international humanitarian law. And on the 13th of June this year, the court also granted intervenor status to Oxfam, Human Rights Watch, and Amnesty International UK. Now, the case is due to be heard in its substantive form in October. The claimant wasn't successful in the first instance in gaining permission to bring this application for judicial review, which is, I think, important to note. But their appeal of that decision, as it were, has now been rolled up into the broader hearing, the merits of the application itself, and that, as I say, is listed for October. The latest press release, I think, in relation to this, gives a general flavour of the approach of the parties in bringing this challenge. So Al-Haq is being represented by something called GLAN, Global Legal Action Network, and their latest press release in relation to this case states that new testimonies obtained in Gaza reveal Israel's systematic torture of Palestinians, undermining assurances to the UK government. And they state that evidence of, and I'm quoting, depraved Israeli war crimes grow as lawyers call on the UK government to halt arms sales ahead of court hearing. It really seems to me that over the last 9 months that this matter has been developing, the allegations are getting more and more extreme. And I think it's instructive to consider what they call extensive evidence that they have filed, namely 14 witness statements from Palestinian doctors, aid workers, what they call victims of torture, and others, including a journalist, they say was attacked with a tank while reporting, and the wife of a doctor tortured to death. They also include testimonies from foreign doctors who've been on medical missions to Gaza, which they say have been all collected with the assistance of the International Center of Justice for Palestinians. 800 pages, they claim, of open source evidence, which they say includes attacks on hospitals, medical facilities, and what they call as objects indispensable for civilian survival. They're talking about controlled demolitions, sniper attacks, attacks on evacuation routes, and burning and looting civilian property. In particular, these allegations of routine or systematic torture that are most recently levied strike me as seeking to discredit the many filed, recorded, documented confessions of war crimes, crimes against humanity, and acts of genocide by these terrorists. And they seek to link all of this to weapons, in that they say the UK weapons are likely being used in targeting decisions that have been made on the basis of information derived from torture, which they say is not only unlawful under international law, but also renders the military conduct and decision-making wholly unreliable. Now, the government set out its intention to review and update the evidence base and assessment that it has made to substantiate its decision to continue supplying arms to Israel, and to do so every 2 weeks, supplemented by interim assessments that cover significant developments as required. And that includes an overall analysis of the nature and the dynamics of the conflict, covering the political, the military, the humanitarian, and the human rights contexts, but also analysis of statements made by NGOs, international bodies and partner countries relating to Israel's adherence to international humanitarian law, and also an analysis of Israel's commitment and capability to comply with IHL. And that includes statements made by military and government representatives and information regarding military structures, processes, training, and analysis after the event. So it's important to recognise that what the government say they're looking at is an analysis of Israel's track record on compliance, including legal analysis of specific allegations of IHL violations. And there is a separate analysis of alleged breaches, in particular Israeli airstrikes or attacks by the IDF on the ground, including those, they say, that have been highlighted by credible NGOs and international organizations. And I think that lies at the heart of what we have seen driving not just this particular case, but also the media agenda over allegations of violations of international humanitarian law that are underpinning these calls for arms embargoes. It's the involvement of international organizations, of human rights NGOs, those that have now intervened in this case, originally brought, as I say, by Al-Haq, but also that documentary narrative that underpinned what became quite a famous letter written on behalf of many lawyers here in the United Kingdom to the Prime Minister under the previous government, demanding an arms embargo, also pretty famously misrepresenting the Provisional Measures Order of the International Court of Justice from January, from the 26th of January this year. That was subject to a very detailed response by UK Lawyers for Israel, which gained far more signatures, I have to say, than the original letter, and which was then ultimately vindicated also by the International Court of Justice former President Joan Donoghue. So all of that essentially sets the scene for what we've seen under the new Labour government. And one of the more concerning aspects of recent developments includes reports by a number of newspapers, including the Daily Mail, and also the Jewish Chronicle, that despite David Lammy, who is the new Foreign Secretary's commitment to launching a full-scale review of the position on arms exports, what had in fact happened was a suspension of any new licenses to Israel pending a policy decision on what was going to happen with export licenses as a whole. That hasn't been fully refuted either by the Foreign Office or the Business and Trade Department here. All we've heard subsequently is that the Attorney General, Richard Hermer, again new in his post, has indicated that he will be intervening to ensure that the Foreign Office analysis and legal advice that is provided adheres with the relevant frameworks of international humanitarian law that the government is expected to apply. Those were set out in some detail by the government in its response that I set out in relation to this case that was brought by Al-Haq. So the situation is developing. It's of concern, clearly, that the government seems to have at least suspended arms licenses before that review is complete. That would very much suggest that this is a politically motivated decision rather than one that is happening on the basis of an informed legal assessment. But in the context of our discussion of lawfare, it's really important to understand that this is all happening in the context of these legal applications, the judicial review application that I've set out, which is really seeking to put pressure and create as much of a media storm around this as possible to make the government's position as uncomfortable as possible. But so far, I certainly cannot see these legal challenges necessarily being successful.
Okay, what I'd like to do now, thank you, Natasha, thank you to all of our speakers so far. What I'd like to do is to go back and give a little more context, factual context, to each of these, well, not the specific cases, but just, you know, the audience is kind of mixed, I would imagine, between Americans, Israelis, some Canadians, some British, so to make sure that we even the playing field in terms of that. So I'll ask a couple of fact-based questions, and then I'd like to move, as we start to conclude, to ask more about the kind of international legal elements here and to what extent they are truly at play, although, let's say, Natasha, you've certainly touched on it in your initial opening. So Eugene, I'd like to go back to you. The issue of settler violence is being reported on in Israel. I think people are certainly becoming a bit more exposed to it or acquainted with it than in the past. There's some issue requiring, at the very least, an Israeli law enforcement response. Can you speak more to what's actually happening on the ground and whether the EO, the executive order, is actually tied in some way to solving that problem? You are muted.
Thank you. Sorry. I want to stress again that the executive order is not aimed or confined at settler violence. That is, the executive order has provisions that allow the administration to sanction people who have not been even alleged to be involved in any kind of violent conduct. As for violent conduct, it allows sanctioning people for anything from serious violence and killing to property crimes. And it seems most of the people sanctioned under the violence prong have been sanctioned for alleged property offenses. As in all places, clearly there is law breaking and violence in the West Bank, and Jews would not be excluded from that. The notion of an epidemic of this seems to be misleading. In a Knesset hearing in March 2024, the chief of police for the Judea and Samaria district reported that half of the complaints made by Palestinians of claiming settler violence to the police have proven to be false and ideologically motivated. He also said that over the past year, there has actually been a decline in this category of crime. Now, certainly there is violence and property crime everywhere, including in Washington, D.C. and Chicago, but we don't see the administration freezing bank accounts of people involved in that. The disturbing thing about the executive order is the extent to which it allows people to be sanctioned without any demonstration of their actual involvement in violent conduct of any kind, and the use of this overwhelmingly against Jewish individuals to the actual complete exclusion of Palestinian individuals, despite the fact dozens of Jews have been killed by Palestinian terrorists in the West Bank just since October 7th. The Fatah party, which runs the Palestinian Authority in the West Bank, has proudly boasted of 1,500 attacks in 2023 against Israeli targets. And indeed, the Palestinians have an official system called pay for slay, which Congress has determined to essentially be a murder for hire system run by the Palestinian government, which pays people who commit crimes against Israelis and are caught or killed in the process, which makes the Palestinian government implicated in all of these terror offenses. Yeah, and that's not a question of fact, right? That's already been determined by Congress in the Taylor Force Act. None of these people have been sanctioned. Our lawsuit does not cast doubt on the administration's power to sanction people involved in terrorist like violence, but the use of foreign sanctions power without based on allegations by political groups fundamentally undermines constitutional rights.
Okay, I'm going to turn now to Joanna first, and then to Natasha, to just give a little bit more context as to what's happening in Canada. And Natasha, you have your choice of the UK or Europe more broadly. I want to saddle you with an entire continent. So Joanna, could you give just a bit more sense of the political and social context? I know you also started to speak about this in your opening, but the political social context in which the case you discussed is occurring.
Yeah, so the instances, as I'm sure many people on this call will be aware, of anti-Semitic hate crime in Canada since October 7th are all, even for me living here as a Jewish person, almost too numerous to list. Most recently, last week, a letter that contained a bomb threat and a note that said, "You will all end up in a pool of blood and none of you deserve to keep living," was sent to over 100 Jewish institutions in Canada. In addition, multiple Jewish schools, synagogues, community centers, Holocaust museums, Jewish neighborhoods have been vandalized, had rocks thrown in their windows, gunshots, usually at about 3 a.m. when nobody is going to be there, but not in every case. It's a regular occurrence every week to see marches in the streets of Toronto and on Parliament Hill in Ottawa shouting, "Long live October 7th." And ours is a government which brought in basically war powers and froze bank accounts in response to the 2022 Freedom Trucker Convoy. So the fact that the government has been very muted and equivocal in their response to this, almost always mentioning Islamophobia in the same breath as anti-Semitism, in some cases just obfuscating, responding. And the famous line here is, "This is not who we are," even after 10 months of demonstration that for some of us, this is who we are. And the last thing that I'll mention is that the Trudeau Liberal government endorsed and the House of Commons passed a non-binding motion in March of this year that endorsed the recognition of a Palestinian state. This was brought by the NDP, which is the sort of far left party here. And there were some last minute negotiations with the Liberal Party that added some verbiage about the recognition of a Palestinian state within a two-state framework, et cetera. And it also ceased arms exports to Israel. So that's a kind of bird's eye view of the situation here.
Okay, thank you. Natasha.
I'm really pleased to be getting feedback from the audience in real time, not least a question to me as to why it is that I listed all of the allegations that are being advanced by Al-Haq in this particular application. And I'm afraid I did so on the basis and on the understanding that the sort of audience we're speaking to knows what to do with those allegations, which is put them very much in the incredible box. Plainly, none of what is being advanced in the context of this case does carry any currency or accuracy. And one way that we know that is on the basis of the continuing legal assessments conducted, not just by the UK, but also by the United States. The policy as regards arms exports hasn't changed. There was recently here in the UK quite a big political stink as to whether or not the last government was going to publish the legal advice that it had received on Israel's compliance with international humanitarian law. And I have to say that this present government that was calling on the previous government to publish it also hasn't seen fit to do so. But the implication in the context of the decision that has been taken to continue arms exports is that this advice, as the advice the Americans spoke about in public terms, endorsed both Israel's capability to comply with international humanitarian law and its commitment to do so. So the types of allegations that we have seen being advanced do not carry any accuracy or credibility to them. Nonetheless, they are part of this legal activity, this lawfare that we are speaking about this afternoon, and lawfare being an abuse of legal processes and legal systems and legal applications, such as this judicial review application, is necessarily predicated on, unfortunately, false information and untrue allegations. And I think it's important to highlight in the context of this case and of the general media discussion that we're seeing around these allegations is that they are being supposedly substantiated by international organizations, by NGOs. We have seen an army of NGOs established now over multiple decades with the agenda, the purpose, if you will, of spreading false information about alleged Israeli violations of international humanitarian law, war crimes, you name it. And that has also fed a great deal of the media furore that we have seen endorsing similar accusations, endorsing, unfortunately, in so many cases, the propaganda of the internationally prescribed terrorist organization Hamas. So that's the important context that I need to put this particular example of lawfare in, and extrapolating it out, if I may, Eliana, taking up your invitation to talk about the international side of this, I think it's inextricably linked with the sorts of activities that we're seeing, importantly, at the International Court of Justice, where we've seen recently the advisory opinion be given based on reams of false information, not just reports by NGOs, but also, unfortunately, official UN reports that similarly propagate these sorts of false allegations against Israel and against Israelis in particular. And likewise, we have seen that at the International Criminal Court. And again, UK Lawyers for Israel put in a detailed submission highlighting all of the inaccuracies, the false information that was put forward by the prosecutor at the ICC to substantiate his application for arrest warrants. Karim Khan released a public statement summarizing that application. Every phrase of every sentence of that public statement summarizing the application was incorrect. And we're seeing this snowball effect of these false allegations being repeated often enough, starting to filter into legal decision making. Now, the International Court of Justice advisory opinion is not legally binding, but the question of arrest warrants at the International Criminal Court, which is now before Pre-Trial Chamber 1, it has to make an assessment on the basis of, unfortunately, the false information that the prosecutor put before it. I mean, that could have very serious, significant implications for individuals. Not only Netanyahu and Gallant, who are currently the subject of that public application for arrest warrants, but of course any other applications that might follow. So drawing together, the individual example I gave here in the UK, but also the involvement of international organisations and NGOs in fueling this process, both domestically here in the UK and also internationally at these international legal institutions. We're seeing, I think, an increasing effectiveness of these lawfare initiatives. And I would finally just say that I think that comes with the very problematic effect that this is calling the international legal system, and then by extension, domestic legal processes, to the extent that they are also utilized by individuals looking to pursue these lawfare agendas, it has the effect of damaging the credibility both of these legal institutions and the legal processes. And that doesn't just affect Israel badly, but has potentially dire consequences for the rule of law far more broadly.
So again, thank you. We're running slightly short on time, and I'm going to take my remaining questions and condense them into one. Eugene, your camera is off, by the way. So picking up on the thread that Natasha's now laid out, I would first of all invite comment from Eugene and from Joanna on the international legal aspects that Natasha's mentioned and how they relate, of course, to your own stories, your own cases. And then the question would be from there, kind of a two-parter. One is how you think the attitudes in your respective countries, the countries that you're working in, are being not only affected, but what will be their relationship to let's say decisions by the ICC or ICJ going forward. U.S. of course is not a party to the ICC. I believe that Canada isn't either. And then if you have some advice for how Israelis should be thinking about ways of in some way influencing the outcomes here to a just and proper result, then I'd love to hear it. And afterwards, we will move to questions. People are invited to put their questions in, and I'll try to get to as many as possible. So, Eugene, I can see that you'd like to go first.
Yeah, so the executive order, it doesn't really have much to do with international law. It's an exercise of the U.S. government's power, which doesn't need to be guided or limited to international law offenses in any way. Certainly, it may have the effect of magnifying the kind of rhetoric in some of the Hague cases, but I see it more as an extension of domestic developments. So, the BDS movement has been working for several decades in the United States. They've been focused on boycotts and divestment. In other words, getting companies to break ties with Israel. Companies aren't interested in breaking ties with Israel. And the BDS movement, apart from efforts I think all of us have been involved in, has been a failure in the United States. At most, they got Ben and Jerry's to pull their pints, and even that backfired. So they've skipped all the way to the S, sanctions, and using the power of the United States, which is much harsher. It also dates back, I think, in the Obama administration, there were efforts to politicize non-profit tax status determinations, which connects with what's going on in Canada. And this was a broader phenomenon of the politicization of the IRS against conservative groups, but Jewish groups were also impacted. And there was a successful case brought by Z Street against a Zionist organization that was denied tax status. And one of the lawyer involved in that case, Jerome Marcus, is one of the lawyers in the Texas case. So definitely there's an idea of delegitimization of Israeli causes, pro-Israel causes, and Israeli charities, which we're seeing around the world. I don't want to give too much advice to the Israeli government because it's easy to criticize their responses to things, but they are fighting a seven-front war at the time, so I assume they have a lot on their hands. I think it is important to respond to the narrative and false allegations of groups that make accusations about settler violence. Again, the police dismiss most of these complaints. It's not the police. I understand the police. It's not the police practice to issue memorandums of why they don't pursue cases, especially non-meritorious ones. But more government information there could potentially be useful. But again, I think the Israeli government is facing a overwhelming avalanche of attacks, both from every country around it, and then in the civil sphere, by actors within its allies, which is why I think it's so crucial for private actors like us to take the lead, and why all of us have to act.
Joanna, and you get to wrap this part of the event before we move to audience questions.
Yeah, well, I saw that there was a question in the chat. So the one thing to mention is that Canada is a signatory to the Rome Statute. So it has pretty much acted in lockstep with the ICC and the ICJ, and often tries to cloak its cowardice in being in lockstep with the ICC and the ICJ. But actually, what I find the most chilling about the whole matter of the JNF is it seems like a lot of its targeting by the Canadian tax regulator was in response to the squeaky wheel of independent Jewish voices, which of course represents a tiny, tiny fraction of the Canadian Jewish community, just to be clear. But if it does suggest that they are responsive to squeaky wheels, so maybe one of the matters that maybe one of the steps is for other wheels which represent more of the Jewish community need to simply be more squeaky. And also just to have the blatant double standards laid bare. So one of the questions concerned the organization Samidoun, which is closely affiliated with the Popular Front for the Liberation of Palestine, which I believe there's evidence participated in the October 7th attacks and is a listed not-for-profit operating in Canada. Its executive director is a woman named Charlotte Cates, who regularly hosts rallies praising October 7th. The Canadian Israel Jewish Advocacy Center has been pressing the government to at least list Samidoun as a terrorist organization since 2021. And as far as I can tell, it hasn't gotten much traction. But the double standards and the hypocrisy are completely galling.
Well, thank you all again. And we are now going to start with audience questions. There are two relating to a legal doctrine that Eugene has written on. I don't know if this is on purpose, but it says that Natasha would like to answer the first question on why the UN doesn't view Israel's borders through, Eugene, you're going to have to help me with the Latin.
Utipoteditis juris.
Juris, okay. And can that be changed? So in the answer, please explain the doctrine. And Eugene or Natasha, which one would like to take? Eugene.
Oh, wait. I thought Natasha.
Why she's seating. Why doesn't the
Eugene's written the book on it, so
no. So on this, I actually haven't written the book. So I'm really not good at answering questions like this, which is why doesn't somebody else who's not me not do something that they're not doing? I don't speak for the United Nations. I can tell you neither the United Nations nor the International Court of Justice has addressed the utipoteditis juris argument. So they have not stated a reason for their not doing so. That is to say, it's not a reasoned or deliberated action that they have spelled out the reasons. The dissenting opinion in the recent ICJ advisory opinion actually discussed the utipoteditis issue very strongly, endorsed it, but also pointed out that the principal opinions did not address it at all, which is interesting because the way usually courts work is when a dissenting opinion raises an important point, the principal opinions will at least speak to it in a footnote to explain why they don't agree with that opinion. But they really don't mention the word utipoteditis juris at all. So I don't know. You'd have to ask them.
There is a follow-up question on this doctrine, which you still have to explain, which is the strongest argument against your view regarding the application of this doctrine to the status of the West Bank. And if the West Bank is deemed non-occupied, would Israel have a legal duty to grant citizenship to all its residents?
If there was a really strong argument against me, I would adopt it.
Well, okay, but can you at least explain the principle? And I promise we're moving on.
Yeah. So again, no international organ, body, or court has elaborated why they do not apply the utipoteditis juris principle in this case. At this point, I think clearly they're going to not apply it because they haven't applied it for so long. It would be an embarrassing admission to say we have ignored a basic international legal doctrine that we use everywhere else in the world for 70 years. Iure paritetis juris is a doctrine that says that the borders of a new country, typically that emerges out of imperial decolonization, imperial breakup, federal defederalization, the borders are the borders of the last pre-existing administrative unit in the territory, which would mean the borders, for example, take Ukraine, as Vladimir Putin did a decade ago. Under this doctrine, the borders of Ukraine are not those areas of the former Soviet social republics where mostly Ukrainians live, or those areas that were, rather, they are those areas that were part of the Ukrainian Soviet Socialist Republic at the moment of independence. That would include areas which have Russian majorities, such as Crimea, who may be extremely unhappy about being part of this country. But that is the doctrine that is used to determine borders around the world. But again, that was not the principal point, I think, of this Hayroot webinar. So I would direct you to my article with Professor Ali Bell on the subject, which is available online.
I think the Arizona Law Review article sets out the position in a fashion which is impossible to refute. It's extremely telling that not a single international legal institution, or indeed, so far as I have seen, a single international law academic, has been in a position to explain why this rule would not apply to Israel. And so I'm going to disagree with Eugene, if I may, simply on one small point, which is that I think it's far more embarrassing for international legal institutions to continue to ignore what is otherwise a universally applied general rule of customary international law. The one piece of analysis that I would pick up, and I note that albeit it is now on the court record, uti possidetis juris, in terms of its application to Israel through the Vice President of the International Court of Justice, Julia Sebutinde, and her dissenting opinion, it was flatly ignored by the majority opinion. It was grappled with by the previous prosecutor of the International Criminal Court when the court considered in 2021 the question of jurisdiction over the alleged crimes committed by Israelis. And in that case, the prosecutor sought to suggest that the principle of self-determination would trump the application of uti possidetis juris in this case, which is, of course, flatly contrary to the International Court of Justice's findings in the Burkina Faso Mali case in 1983, where it talked about the establishment of this rule, its emergence, and the fact that, of course, it applies because of the importance of territorial integrity in a fashion that would even trump self-determination. So the continual legal acrobatics that we have seen from international legal institutions, from people like the previous prosecutor, Fatou Bensouda, and from several international legal academics, in order to contort themselves in a fashion to say that this rule doesn't apply without any legal justification, I think is extremely telling. And the fact that it's gaining more prominence now in international legal discourse vis-a-vis Israel because of the very brave dissenting opinion of Julia Sebutinde is to be, I think, celebrated and encouraged.
All right, I'm going to ask, I think, at least one more question. I think one that will turn to all of you. We have a question regarding the status of the cases brought against, well, the status of the cases that you all discussed. So, and I suppose in the case of Eugene, for instance, have you been successful in getting things like preliminary injunctions to negate the enforcement of egregious policies? There's a separate question regarding the Canadian case, whether the JNF asked the Minister of National Review to restore its status. And Natasha, in your, well, I suppose your case hasn't actually gone to hearing it, but do the arms embargo cases and judicial reviews involved in any way address violations of IHL perpetrated by Hamas that occurred on October 7th and continue against the Israeli hostages? So each is free to take their question, and we'll see how much time we have left.
Sure, I'll start because it'll leave a lot of time for everybody else. We filed our case like a week or two ago, 2 weeks ago, I think. So so far it's at the absolute earliest stages. Government has 90 days to respond.
Joanna?
Yeah, so also this decision was just announced just a couple of weeks ago. So I think that the JNF is still in their early stages of filing. I don't know if they're going to be seeking interim urgent relief in the form of lifting the revocation, which I think they would have a strong application to do if their legal team said that they've identified 200 instances where similarly situated charities have been allowed to proceed without the revocation, certainly until all the judicial review procedures have been exhausted. That suggests to me, reading between the lines, that they are going to pursue that argument, but they have not said so publicly yet.
Of course not. The judicial review application makes no reference to the celebrated crimes of Hamas. In fact, it talks about Israel's military offensive against Gaza from the 7th of October. So the separate reality that those bringing this application are living in is perfectly plain from the claim that is being advanced. What I would say in terms of our own ability to see off these lawfare initiatives is that we have been told that the UK Lawyers for Israel letter, which refuted every aspect of the false information that was being put before the Prime Minister, a letter that was signed by hundreds of lawyers here in the United Kingdom that I mentioned earlier, misrepresented the International Court of Justice Provisional Measures Order, but also put various other falsehoods forward in order to seek to justify its calls for an arms embargo. Our careful response in a number of letters and subsequent evidence to the Business and Trade Committee in Parliament, we have been told had a significant impact in the previous government deciding not to institute an arms embargo. What that looks like under this current Labour government is another question altogether, I'm afraid, because albeit that the legal analysis and legal arguments about whether or not Israel has committed any breaches of international humanitarian law, or whether that might mandate a change of the UK government's position vis-a-vis arms licenses and arms exports. Ultimately, this is a political decision. And I think the fact that certain arms licenses have already, by all reports, been suspended before that legal review has been conducted is indicative that this is a political decision. It's one that, unfortunately, the Labour Party is having to make after a history of real deep-seated problems with anti-Semitism in the party, and where in the last election it was also outflanked by a number of MPs that stood as independents on a single issue, which was Gaza, and essentially anti-Zionism, anti-Semitism. And in that context, there is immense pressure on this Labour government to take a very hostile stance towards Israel. We've also seen that with respect to their withdrawal of their concerns, which was supposed to be filed with the International Criminal Court on the question of jurisdiction and issues pertaining to the Oslo Accords. So there is a conflation, if you will, of the political pressure and these lawfare initiatives. But so far, putting the record straight, arguing the legal case has kept, I would say, the previous government certainly on the right side of these legal determinations. And I know UK Lawyers for Israel and others involved will be continuing to apply as much pressure as they can to ensure that lawfare initiatives are not going to be successful and that the law here is properly applied. Right.
Last question, as we've now come to an hour and 5 minutes. Thank you for everybody who stayed. Thank you for everybody who gave us the time tonight. We have within the questions an offer from a retired judge to volunteer with UKLFI, Natasha. So well done. As well as questions about, there was a question, I think the individual's now left the conversation, about in America, at the very least, how people might be involved, even, litigators or ex-litigators might be involved in helping push back against some of these things. So if you have suggestions, I'd love for you to share them. And I will specifically, add to that this question of, information from what appear to be extremely biased NGOs being used in some way in each of the contexts that you mentioned, and whether they're not simply large ways in which people might be involved or specific ways of addressing that problem. So, Eugene?
So certainly the government has a lot more lawyers than we do. So any help of manpower or financial resources is always appreciated. This is a very big task we have embarked on, and feel free to contact me.
Okay. Tasha?
I'd say likewise. Thank you very much for the offer of support. We really rely on volunteers, and I'm really pleased to say that in the last 10.5 months, there has been a real influx of people, lawyers in particular, wanting to assist. But there has also been an absolute explosion of work to be getting involved with. So that is also extremely welcome, and anyone can email info@uklfi.com to get involved. One of the things we're also seeking to do is put out briefings that refute so much of the misinformation that is being circulated by these NGOs that you've referred to. So the combination of that and then also deploying that correct information in the relevant contexts is time consuming, but at least we have the law and the facts, the truth on our side.
Joanna, you want me to share this link with the...
Yes, so I just put in a link to a petition that the Center for Israel and Jewish Affairs has been building to have Samidun, which is the PFLP affiliated not-for-profit, to have it listed as a terrorist entity. So everybody can sign that. And then I would just add that JNF Canada, even though it can no longer issue charitable receipts, could use a lot of support. We know that litigation against the CRA has like 90% fail rate. They have, an unlimited bench of lawyers, much like in other countries. So they very much need your support.
Right. With that, I would love, again, spend a night of gratitude to thank you all for giving your time. I hope to see you in future events. I hope the audience benefited from the knowledge that you've shared with us tonight. And let's all work together for better times.